Shall we start? What
Yes.
do you think?
Yes, we can. I'm sorry for the little rush.
Sandra is, I want to introduce our guest, our special guest. We decided to make our meeting, we have decided it for a long period before the coronavirus attacked us, but unfortunately we were not able to do it offline. There was a really interesting project. We wanted to make it both in Russian and in Germany, to make a comparative meeting, if we can say so. But so we are here today, and we have online conference, online roundtable, and I hope that it would be also very effective and interesting, as today we have Sandra. Sandra is Sandra done her magister degree on medicine law, and I think on medical law, and I think that it would be very interesting to listen to the situation about medical law in Germany, because here in Russia these aspect, this sphere is rather new, and I think it is only at the beginning. Actually, I can bring an example. In our Ural State Law University, there is no such kind of course that can be given to students. We just can speak about some cases in the course of civil law or business law and so on, but we do not have special subject, and that's why I think it's very unique that we have now an opportunity to listen firstly to German experience rather than to our, but still. Sandra, I want to give you a word, and I want you to lead the process, and if you need some help, I'm here and I will be with you as we agreed.
Okay. Yes, great. Thank you. Then at first I will try to share my screen, I think.
Yes, of
Is
course.
it like the green button, right?
Okay. Try again.
Yes.
If you need help, we have Ilya.
Yeah.
Ilya Novikov is our student of the second year of education. He is also the constant member of Law Club, and so he can help you. You can ask some questions. So he's here. He's eager.
Okay, but can you see it or?
Yes, we see that you. Yes, great. We can see it. Medical law in German.
Yes, so I will just start this. So, okay, great. Then,
and before Sandra, and while Sandra, I'm sorry, one more moment for my interruption. I apologize. I want to apologize, and I want you to be free to ask any questions you want. And we agreed with Sandra that our meeting would be like a discussion. So we would discuss. Sometimes Sandra would ask us questions, and we are supposed to give our opinion. I think that is the productive way of going further, and so do not be afraid to answer just your opinion. I always think that it is very, very interesting to share and to decide together. Thank you. Sandra, please.
Okay, then thank you. In advance, I think I have already to apologize because it's a very complicated topic. So I just try to figure out which aspects could be interesting to all of you as a start. And so the first question, or the structure is just, we will talk some minutes about the general aspects of the background, especially about the medical treatment and if it meets the requirement of bodily harm or not. And yes, as you can see, I will talk about some cases, which hopefully some of you have already read, but in other case we can figure out what they concern. So the first question to all of you is just what do you think? What are the main issues of medical law? So which topics, which cases, which areas of life and law will meet in this area? I'm interested in hear about your ideas and opinions. So feel free.
Okay.
Yeah.
Who wants to answer? Who has any idea what is medical law is? Okay, yeah, maybe you can help us.
Well, maybe this is a subject of law which tries to. Oh, can you hear? Yes, you can hear me.
Yes.
Which tries to regulate relations with maybe in medical aspects or something like this.
Yes, so but what persons are involved, do you think? Or which subjects?
Well, firstly, patients or how?
Yeah.
Yeah, patients and doctors.
Okay. Yeah.
I have also an addition to Ilya's answer. I think that it is not only doctors. I think that it could be, I'm not an expert, but I think that it could be also medical departments or facilities or some other hospitals, as we can say, as the subject, as the person that has rights and obligations.
Yeah. So, as you said,
What
of
else?
course,
Maybe there
okay.
are,
Sorry.
Maybe there are some other opinions. Do we have?
I think it could be about medical researchers, and not only about patients' rights, also about patients' relatives' rights.
Mm-hmm.
Maybe this.
Okay, thank you very much. Mm-hmm. Maybe I do not know. Sandra is an expert. She will answer.
Yeah.
Okay.
I just wait if there are other suggestions. Then I will continue to answer this question.
Okay, I think that we can continue. Mm-hmm.
Okay, so yes, of course, as you already said, it's about the patients and the doctors, and of course the medical staff. So psychiatrists and just the caring personnel or the nurses, for example, and in addition, also like insurances and thus the social system of a government or the state, in this case Germany. So this is why medical law is not a sphere of just civil law or just criminal law. It has something like it rules the approbation of medicines. So if they have the license to practice law, in this case it's administrative law. And of course, all of this is influenced by the European law. But yeah, according to this whole sphere, it's quite necessary if you want to practice on this sphere. You have to get the title as a specialist lawyer on this area, and you can not just be, for example, the criminal law who sues, I don't know, the medical doctors which hurt someone or something like that. So yeah, it's also in comparison to other fields, relative new area of law in Germany, but I guess it has already a good practice for some years. So this is why we have this master's program on our university. And in civil matters, the main topic or the main issues are in relation between the patient and the physician or the treating party, which could be the medical facilities, like you mentioned. And today I just want to talk a little bit about the liability in those relations between patient and physician as an example, and liability and possible compensations. Yes, so that's what this whole sphere is roughly drawing.
And I want to ask Sandra, could you please tell us whether all scientists in Germany consider that it is an independent sphere of law, independent branch of law, which has the right to exist?
So you mean if it's recognized?
Yes, it's recognized.
Yes, I think there's no question that this is an own area which just has influence or is influenced by all the other areas. So about this, there's.
But it is a complex branch of law, as far as I understood. Am I right?
Yes, and even if you have this special title, then you probably will not handle cases in every part of it. So, for example, I would like to focus later in future on the administrative part, or the part of is somebody. No. I don't know why it starts. But...
Yeah, it's okay. So.
Okay. No, have you been already there? Yeah. Then in civil matters, to continue, the core issues. I don't know. I think I'm not acting right now. Okay.
Okay, we have your full screen, not only presentation, but the full screen.
Okay. I don't know, it tells me that I'm going to be...
But if you cannot handle with this, it's okay. We can see, for me, it's not a problem to see the picture of the presentation in the small variant. So you can continue in this.
For me, it's also not a problem.
Okay. Yes, as the core issues, back to the topic. The history on this sphere is a little, I don't know, it changed a lot in history. So let's imagine 30 years ago, it was not a problem if you went to the doctor and he told us to do this, take this medicine and stay in bed for 3 days. Then without any disagreement, you just did what the doctor told you. And in the last years, this attitude, I would say, changed a lot. And people want to get more involved. So in the center of medical law is always the question of the patient autonomy and the self-determination, so that the medical physician cannot just, they don't have the right to tell you what to do without your agreement. And this, of course, has influence on civil law, because there are regulations about this, and to agree to some suggested treatments, the patient must be informed. And this is a quite discussed theme, the informed consent, which is a base for a valid agreement, because it depends on the treatment, on which level you have to be informed. So there's no general rule about how exactly the information about an upcoming treatment should be. And this, yeah.
So technical progress is not with us today.
No, I don't think so.
In the world.
But I don't know, maybe should Ilya tell me?
I think that
it's fine for internet. There are always some guys.
So it's a very interesting situation. I've heard about this. Ilya told me that it's the practice of such conferences, big conferences, when somebody, it seems to me, teenagers or somebody else, try to interfere and try to make all of us to see what they want to see, and they are. Okay. I think that it's very funny. Funny. But for us, it was the maybe like the short period to take off and to see what will happen if people will take drugs and some other things.
As a short reminder.
This video, it wasn't the part of the presentation.
No, it was not the part of the presentation. I'm sorry, Sandra, to interrupt you. There is, I saw that there is Vladimir Sergeyevich Belych. He is the head of our business law department, and we kindly ask him to join us and to start our round table. So if it is possible, Vladimir Sergeyevich, I'm sorry that you are in the middle of the presentation. So, but I think it's okay when we have such kind of technical obstacles, technical position, and offline seminars and round tables. So, Vladimir Sergeyevich, could you please tell us some words if you would like, please?
Thank you very much, Maria. I am very glad to see you. Welcome, my dear colleagues. This conference, this term is very, very interesting and successful, especially now in condition of the coronavirus pandemic. And firstly, I wish you a good health and very the biggest problem in the old world. In my practice, I am the advocate. Sometimes I meet the case connected with the medical law. No, for me, medical law is the exotic law in Russia. No, because medical law must have the subject of matter. Medical law have the special principles, methods of the legal regulations, and so on. However, I consider that medical law is must teach and the science and the different juridical university. Very, very nice. And secondly, I want to say you about some biggest problem connected with the medical law in practice. No, for example, the abuse of the medical rights from the doctors. Another problem connected with the damages of the application of medical law, damages of health, of death of the persons. I wish to you to be continued, and I wish to you a health, and to be our cooperation to be continued. Bye bye and see you later. And as to me, I want to rest outside in town.
Thank you very
Thank you
much,
very much.
for your wishes. We also wish you to be safe, to take care of you and your relatives in our days, and so thank you very much that you found time to tell us about your experience and to share your opinion on the topical issues that we have chosen to discuss today. Thank you very much.
Thank you very much. Bye bye.
Bye-bye.
Bye-bye.
Sandra, I'm sorry that so there was twice that we have interrupted. One was not on our fault, and another was we want to give a word to Vladimir Sergeyevich, as we also agreed. And so please, we are eager to continue and listen further.
Absolutely no problem. That's why it's a round table, I think. Okay, so where did just the first question? Should I just talk without the presentation, or will we be able to? Should I try to share it again?
Yes, I think.
So I tried again. Sorry, the first time using this mode. So can you see it?
Yes. We see the full screen.
Okay.
And we even see Deutsch letters. So we can lesen.
So we stop there, I think, with the informed consent. So I think the idea on this might be clear, that years ago there were no problems, that that you had no doubt about the treatment the physicians were told you or were providing you. So that changed a lot, and today everyone is just thinking about, is it really the correct way, or isn't there a better way for me to be treated on this disease? Or yes, there are thousands of opinions on just one disease, I think. And this, of course, depends on a very rapid development in the medical, technical, progress. Yes, and therefore the informed consent is a discussed topic, but the patient autonomy and the self-determination itself are not. And therefore, some years ago in the German civil code, which is called BGB, there were some provisions added, which are in section 330 and the following, and there are some regulations about the treatment contract. So this kind of contract is added as a known thing. So years ago it was just considered as a service contract, because for sure in this treatment contract there's never the obligation to heal something or reach healing of a disease, because it can't be promised in most cases, I think. But now it's just declared as an own contract, which makes the legal handling much easier, because it's just very detailed, written down. Yes, and in those regulations, on detail regulated are compensation due to malpractice and the special requirements like the consent and all those stuff about in which time it has to be done, and which are obligations and which are exactly no obligations. What kind of documentation the medical doctors have to follow and stuff like this. I think before we start about the consent, it has to be mentioned that the I would just ask you this question. What do you think about the requirements for bodily harm? So if you are going to a hospital and get some treatment, just on the basis, does a surgery has an effect to your bodily health? And so would the surgery itself just be a bodily harm without thinking about consent or agreement on this? What do you think?
Ilya, you want to say something? Yes? No?
About consent.
No,
Sorry.
not about the consent.
If I understand correctly, this is about situation when the doctor tries to help, but occasionally he makes a harm. Yes?
No. It's more general. It's about the question if you are going to the hospital because you broke your leg, and the medical doctor just, of course, he wants to help you, but therefore he has to make the surgery. And this brokers this intervention of a surgery itself could be a bodily harm, because I mean he has to cut something and put something in, and so could it be bodily harm?
And the question is whether you have to give the consent on the...
No, sorry, that's nothing about the consent or not. It's really just a general question, because that's maybe a basis for do we need consent, or is it just not necessary?
Well, maybe it's not necessary, but we need to check the whole situation. If the person could die because of this broken leg or arm or something more serious, and the doctor saved his life, maybe in this situation, something happened with internet connection, I think.
Yes, Sandra is not with us. Yeah, she's absent.
Yes.
Okay, but we can discuss without Sandra this issue, and meanwhile she will come to us again. So, what do you think, all members of the conference? Do you think that it's necessary to give your consent or not?
I think that consent is not necessary. It's formal in Russian, and all operations will be done, and consent. Of course, it can inform you about the harmful consequences of all operations, but what a patient can do? Can he afford all these consequences or not? I think it's just formal and not necessary.
Okay, and if, for example, it's really the situation of emergency that, or the person is unconscious, so he is not able to give his consent to express his agreement or disagreement with some things that doctors have to do. So in this case, I think we cannot speak about the consent at all. So otherwise it would be something crazy to suppose the unconscious person to give his agreement, to express the agreement. So it's very difficult to understand where is the balance of this situation, isn't it?
Yes, it is, and I know that in America there is consent. A patient can forbid consent on reanimation, and we don't have such an opportunity. For example, a patient who doesn't want to be reanimated. In America, he has the right not to be. In Russia, he doesn't have the right because we have special regulation on emergency and special regulation on reanimation opportunities. It's really a very it's a very, very big question about consent. I think we have many views on this, and it's very interesting what Sandra does.
Yes, she wrote me in WhatsApp that her laptop was so stressed. I don't know why. That laptop decided to reinstall himself, to restart it himself. But laptop was not. Laptop didn't do it before. Hasn't do it before. So it just the situation, because for Sandra, she's not so experienced in giving lectures, and that's why she maybe I feel she wants to do it as better as possible, and that's why it has happened. But so she told me that I wrote her that we discuss the situation, the question that she gave to us, and she wrote that there are many opinions on that question, and so I think that you are not alone who cannot say the certain answer to the question whether we have to have a consent or not. And so really I think it's not an easy to answer, because whether the person has to have the right or not in such a way, but so it's very, very, very difficult to answer. Okay, who else want to express his or her opinion in meanwhile? To practice English is also very important in such situation. So, especially in the period of self-isolation, when you have no any chance to speak with somebody else except your relatives in English. You can speak with them, of course. If you want to say something unpleasant, you can speak in English, and not to spoil relations with your relatives. Yes, and something. And of course, they can also practice English as well. Okay, let me check. Okay, and while we are waiting for Sandra, what do you think? Do you think that medical law? So you see, in Germany, as far as we understood, in Germany, medical law has its own place in the legal system of Germany. And do you think that in Russia it would have its own position, its own place as the branch of law? What do you think? What can you?
I think that the medical law is a separate part of law in Russia. But we had a master degree in medical law some years ago. Now it is closed, but we had such.
It's something is not clear because of the internet connection. Lisa, could you please repeat one more time? I would understand.
Oh, I'm so sorry. I'm in the village, and maybe there is some problem with the connection.
Yes, I understood that you're on the village and there are some problems with connection. Yes, it's okay. So let's go further.
So I don't think that now the medical law is the separate branch of law in Russia, in my opinion. Yes, and I try to say that several years ago in our Institute of Law in Chelyabinsk, we had a master degree program about medical law.
But do you think that maybe in several years it could be the separate branch of law because of I don't know, of the development of these relationships and the situation around these problem around these relationships? What do you think?
Of course, I want that we and our students, we understand and know about legal norms in medical law. But now, regretfully, we do not know a lot in the sphere of medical law. And that is very, very bad because we cannot protect ourselves in a suitable way. So maybe, but we must develop the research in the sphere of medical law.
Yeah, in Russia, it's very difficult with the creating new branches. So we are just in the situation that we do not have a balance between really necessary branches that have to be introduced into our system, and on the other hand, we sometimes have very, very small branches, or even not branches, but the relationships that are wanted by some scientists to become a branch, and they try to protect these ideas, these theories, and so even there is a problem with the business law. I think that for maybe now it could be said so that business law is the separate branch of law. But even now, for example, at our university, there are some departments that do not agree that my department, business department, has the right to exist, and it's like the kind of fight, scientific fight. Yes. So I do not know why they are so conserved in their in the development of law, because really these I mean, business relationships are vividly have the right to exist, because we breathe with the air of these relations. I'm not sure about other branches that trying to be introduced, but still. So, for example, I give lectures on transport law, and transport law is not considered as the separate branch of law. And I always tell students that it is the part of business law, but it also has a very huge background and very huge legal provisions. It has a very difficult situation with. We have a very difficult situation with these kinds of relationships, and I am sure that the same would be with medical law. So for Russia, it's my opinion, maybe it's not true, but in several years, in 2 or 3 years, the situation would not change, would not be changed, and even maybe in 10 years, I'm not sure. But you know, everything can be, because we also didn't, we were not supposed to be on a distance education this year, yes, and and some universities were not ready for this step. But life told us to do so, and we are ready, and we do it. And so actually we cope with these difficulties. And I think that maybe the same would be with medical law, when as we are in such situation when everything is rapidly developing. So who knows? Okay, we try again. Sandra told me that it's still restarting. I'm sorry, really. This proves again that offline communication is much better than online communication. And I think that human beings cannot live without Sandra, hello.
Oh God, I'm sorry.
Human beings cannot live without offline communication. So it's the nature of human beings. And even technical progress will not push the personal communication abroad, these frames, abroad after the frames and so on. Okay, Sandra, I was very talkative today. Yes, really. I think that everybody thinks that it's Maria Anatolyevna who leads this round table. I'm sorry for this.
Thank you.
Sandra, we spoke about we discussed everything, and
great.
And now we want to know the answer. So there are several points of view on your question, and we did not find the only one, because it could be the situation of emergency when the person cannot, the patient cannot give his consent or so on, or it could, and in Russia, there was an opinion that in Russia we do not have, we have the special legislation on the emergency situations, and we do not need to give to have a consent. Doctors do not need this to interfere into the health treatment. And but there is the same with reanimation, that so some people in, for example, in the USA, they have the right not to be reanimated, so they can express it. But in Russia, we do not have so. Can you tell us what German scientists think of this situation?
Yeah, of course. In general, there is no wrong or right. It is just of course, it depends on the legislation. And as you said, in Germany, it's the same. So in emergency cases, of course, it's allowed to act. But the question behind this is still if it's bodily harm to interact with another one's body without his agreement. And on this, some years ago in Germany, it was decided that yes, always, every treatment is always a bodily harm. So just as a fact. So, well, that's also concerning the patient's autonomy today. Because, for example, if you're 80 years old and you get very sick and you just go to the hospital and tell them, no, I don't want you anything to do with me. I just want to get home and be left. And the doctor decides, no, I want to save her life and I want her to live still 7 years longer, for example. And he just acts and treats her against her will, then of course it's bodily harm. So in this basic sphere, it does not depend on the consent. So of course, every time you're giving the consent, then it's not a criminal action, and it's also not a criminal action if there are exemptions from this rule, and like the emergency cases. But the basis on this is that yes, it is bodily harm if you are just doing any treatment with your patient. And the reason why this is important because I think in the 1920s it was quite used or quite common that it was the scientific saw it the other way around. They thought that medical treatment, which is in a good faith, which is to help people, and you are, just to say it very, very, very clearly, if you cut the leg to save the person's life, then it's not harmful. So in this time, it was seen like, well, I'm saving his life, so I can do it, and it's not a criminal action. And this, according to this patient autonomy and the self-determination, turned around. So today in Germany, it's the basis that, no, generally, it always is like a criminal action, even if it's not sued and even if it's not treated like criminal, but on the basis or the thought behind the civil law regulations is that. Yeah. Mm-hmm. So that's a solution in Germany on this. Well,
maybe we can come to the cases.
Yes.
I think to because I know that you have much more.
Yeah.
Your presentation, but yeah, show us the position of German law through the case. I think it would be also very interesting.
Mm-hmm. Then I think I'm not sure if I should really try to share my screen again, but
I think it's better not to try.
Yeah, could you please share the condition of the case? So could you please show? Maybe you can try to share your screen. You have the case which I've sent to you yesterday. Because I think then it is written for everybody. It would be easier to understand.
Yes, I can, but give me a few seconds, please.
Yes, okay. Mm-hmm. So I think Sandra can go further, so to explain the case, and then we will read it by ourselves.
Just for the organizational thing, okay. Do we want to continue all, or do we want to speak about all the stuff, or just skip to the case 4, which is?
Do you think it's possible to go to the case, or it's necessary to say something?
No. About the topic we spoke right now, it's just easy to skip to the case number
And
4.
maybe the information that you have before the case, we can imply through the case itself. Yeah. Okay. So the first case.
No. You mean just talking about all the cases and speak about the other informations I would have given you before?
Well, can you see my screen?
Yes, we see your screen.
Okay.
Could you please come to the first case, case number 1, because
To the
it's
first,
case
okay.
Yes, yes.
Mhm.
So the case is that patient P had a knee surgery, wherefore she needs care in a clinical facility. After a shower, attendant A told her to wait and not to move, but she did not inform her about the possible consequences in case that P would try to take the towel. P leaned forward, fell off the shower and chair and broke her hip. Which claims could she have against whom? Very tragical situation. Yes, come to the treatment and had some more injuries.
Yeah, but
Well,
it
but it could be really, because when the person is after the surgery, he can be a little bit clumsy and so on.
but that's a very exemplary case, that always the patient looks very clumsy and not thinking on themselves in those cases.
What do you think, dear members of our round table? What do you think? Do we have any? Can we claim somebody if we were the advocates of this patient? What do you think?
Well, can I try?
Yes, of course, I'm happy as far as I can. Okay.
I think there are 2 ways to see this case. The first one, medical personnel, or who was that?
Attendant.
Attendant.
Human attendant.
In some cases, there are some patients who need to be under the attention. It wasn't a great idea to leave this person alone if she knows that this person is a kind of strange, maybe, or she can do something that she shouldn't do. But also, in my opinion, there can be a situation where the patient is absolutely I forgot a word. Виновен.
Liable.
No.
Is in charge.
Oh, yes. In this situation, I think also the patient is in charge because, well, we can imagine a situation where it's anyway, this is a medical building. There are also a lot of dangerous stuff, and of course, she should be. She should move safe or not to move to.
To any place.
Yes.
To be still. To stay.
Because the medical staff told her not to move, and she just ignored them.
And okay, somebody else? Yeah, from my point of view, it's also very difficult to predict the end of this case in front of court, in the court, because so if we would think that clinical facility are in charge, facility is in charge in this situation, it is their fault, its fault, then we would come to the situation when so anybody can do something with himself or herself, with themselves, and so clinical facility would only be liable to compensate moral damages, or to compensate the treatment of the additional injuries that the person had got. So it's very difficult really to answer yes, we have the right to claim, but so what do German lawyers consider?
To be honest, my opinion on this case would have been also like it's kind of P's own fault, because it's quite logical that you should not move if you are sitting on such a strange chair and somebody tells you that you have to wait, because sometimes it just could have been for a reason like she wants to get her dresses, so it's, or her clothes, so not even for leaving her in this room, just turn around and tell her to wait, and then she went forward. And it's more like expecting from the attendant to be like a parent, which obviously could not be the purpose. But the highest court in Germany decided on that case that there is an explicit obligation to tell her what could happen if she does not wait. So just saying don't move is not a clear instruction for the patient. So I think this is a good example to see that in medicine law sometimes the decisions are made like, or with a great regard to the, or comparable to consumer protection. So the patient is
right
often treated like a child, and it's assumed that he can't think on his own. And so in that case, they, P had a claim on compensation against A.
And I'm wondering, Sandra, how could they prove that they do not say this or say that? So it's, you know, it's oral process. And
but A was saying that she explicitly said, please do not move, because in her mind, and of course she thought that it's enough, that's a warning. And so she said this, and it was clear that, so she didn't even try to say, I said something else.
The court made the decision on the words of the attendant, am I right?
Yeah. Yeah.
Very nice.
I'm not sure if that's nice. But the other question, just in short, against whom? Because of course there's a claim against A, but it has to be mentioned that there's no obligation or no contract between P and A, because A is just the staff of the clinical facility. So I think it's kind of the same in Russian civil law, that there's the law of obligations and the law of torts, and so P is just chargeable for
clinical facility.
Yeah.
So the right subject to sue is the clinical facility, the right person.
Yeah.
Yeah, I think it's the same in Russia to find who would be the defendant in this situation.
Yeah.
Okay, and did the High Court of Germany made any? I have a question concerning the regulation. Do medical issues are regulating only by BGB? So it means the Civil Code of Germany, or there are some special treatment, some special decrees of the government or maybe of the ministry of
not
health?
even of the ministry or the legislation. It also can be the guidelines of a hospital or the guidelines of this clinical facility.
The local acts, am I right?
Mm-hmm.
So, and does the person is the person obliged to sign these documents that he is agreed with these local rules, or
no, they're just applicable, I think. If you're getting into treatment in such a facility, then you have therefore a contract, but you don't have to agree on every specific rule.
But when you sign an agreement with the clinical facility, is there any provision in the agreement that you have to follow the rules and that you are aware of?
Okay. That is even regulated in the BGB, in the treatment contract part, but it's very general said. It's just said that both parties have to work together. So yeah, it's just said that everyone has his own obligations on this part, but that's interpretation. And
so it means that patient do not sign something additional, only contract, and contract may not contain the provision that the patient is agreed with these local rules. No,
I'm not sure. I would say it's not common to sign some additional agreement terminations, because it's well, that depends a little on the insurance stuff, because most of the clinical facilities are part of insurance system, and so in fact this insurance will pay, and so it's everywhere the same. So there are no differences between some different facilities, except you are going for a private institution, which is, I don't know, in church, she said, or something like that.
But in private institutions, I mean, in private clinical facilities, you have to be aware of the rules, so they can give you the
I think it's possible, yes.
Okay. So, but do you have a special medical code, or maybe you have some laws, additional laws, not only civil code?
Many.
Many. And are they on the federal level, or they are on the level of each land of the subject of the federation?
It depends, but many are just regulated by the federal states, by the Länder, and some also
but
by.
It's the law level, not the level of governing regulation, or is it?
On every level.
On
you
every
can imagine.
Level.
Yeah.
Okay.
Yeah.
But you do not have the codified act, do you?
As a medical law?
medical
No.
code or something like this? No.
No. There are some textbooks where the most important laws are put together, but there's no explicit medical code.
Okay, so then we can
Continue.
go further. Yes.
Yeah.
Case 2. Key, 9 years old child, has a painful stomachache. When his mother brings him to the hospital, the doctor tells them that a surgery is necessary, else the health of Key would be at risk. His mother agrees. He does not want the surgery to be performed. He is scared. Can the surgeon lawfully perform? Okay, any opinion? To make not only me express my opinion. I always have an opinion, but maybe.
I mean, all of these cases are chosen because there are several opinions. So.
Yeah, thank you, Sandra, very much for these cases. Okay. If there is no opinion, maybe Sandra, you can.
Yeah, I can just.
Your idea, because.
Okay. Yes, of course. Well, as you see, it's about the consent, and you might think that a treatment contract needs legal capacity to act on that way. But in medical issues, it's not relevant if you have legal capacity, which is generally at the age of 18 reached. But it depends on the level of your ability to foresee. So if you can imagine what will happen if you make the decision on that or on the other way. And so this is why children also have to be asked before start a treatment in a hospital or at the medical doctor or somewhere else. And in this case, it's quite discussable if a 9-year-old child has the ability to see how important such a surgery would be. So I would say, of course, parents have to agree. So if the parents don't agree, then there's another way where you have to go to a court and get the like another agreement that it's not in the children or in the child's interest, or it's not the children's well-being decision if the parents are against such a surgery. But in case that the parents agree and the child does not want to, then I would not suggest that this doctor should make the surgery. He should try to convince the child that it's necessary. So it would not be lawfully if he perform as long as K says, no, I don't want this. That might sound a bit strange. And in reality, I think there are many courts who would decide that, of course, it's in the children's interest to make the surgery. And on the other side, how would this case even come to court? I mean, if the child got the surgery and he is not able on his own to sue somebody, so that's more a theoretical case. But it just has to be mentioned that you can't ignore the disagreement of a child as far as he is able to foresee. Yes.
But since what age, since what time the doctor has to ask the child?
There's no age. That's also the issue of this doctor, to find out, is this 9-year-old child already able to understand, or is, I mean, it's clear that a 2-year-old child would not understand anything, but at the moment the child says, no, I don't want that, then I think the doctor has to figure out if he can deal with this decision, or it's just...
And what would be the consequences of the situation if the doctor, on the consent of parents, would do this surgery? What would be the consequences for the doctor? If the person is, I mean, if the child is not able to sue by themselves, so what would be the consequence?
Yeah, that's why I said it's more a theoretical case. But if that happens very often, I mean, it can be imagined that you can act against the doctor's approbation. So you can not sue him, but go to an administrative institution and say that he acted like that, and then maybe something will happen, or maybe not. And on the other side, it's very hard to imagine that a child would say, no, I don't want this, if the parents say yes. I mean, most children are very influenced by their parents' decision. So if the mother says, no, everything's gonna be fine, and stuff like that, then I think most children will be fine with their parents' decision. So yes, as you said, there's no real consequence out of that. It's just like all those cases with consent or not. I mean, after that, the surgery is already done, and he is probably healthy. So.
And I also have a question. You've told us that if the parents do not agree with this medical interfere, who can sue them to make, because, for example, everybody understands that, I mean, doctors understand that the situation, the health condition of the person is not good, and who can change this situation, or nobody can? What does German legislator tell on this aspect? Is any case to do this?
Yeah, the best example for that is about the Jehovah's Witnesses. Do you know them?
Again?
Jehovah's Witnesses.
Witnesses, but Jehovah's.
Yeah.
Okay.
Yeah, which disagree with transferring blood. So for them, every kind of surgery would not be possible. So, and in these cases, it comes back to the idea that the center of a treatment is the patient and not the parent. So it's important to see what's in the patient's interest. And in that case, the medicine would just, would be able to call the court and got the agreement in the children's well-being. So
it would be, the claimant would be the clinic itself.
Yeah, it would not be really as a lawsuit. It's just to get the agreement, you apply for that. But this would be done by the medicines. So yeah.
Okay, thank you. So what do you consider, do we have time to go further, or what would other say?
You can also discuss how it will be in Russia, maybe.
If we have such experts, because I know the situation. One of the doctors told me that it was in Yekaterinburg. There was necessity to make a surgery to the small child. It was not small, it was 11 or 12 years old, and it was a girl. She had problems with heart, and it was necessary to make a surgery on the heart. And they were of such religion that the religion does not confirm any interfere into the health, and that was the problem, because all doctors understood that only surgery could help the girl stay alive, and her mother was against, her family was against that surgery, and nobody has influenced them. So there is not any opportunity. But so the doctor, it was the opinion of the doctor. I don't know if our doctors or hospitals have the right to go somewhere with the claim to make the surgery obligatory. I'm not sure, really. But the situation was very sad, because
I mean, it's not easy for the doctors to apply for that or to get the agreement, and I think that's
And can I ask? And what about some agencies? For example, we have an agency which can get away a child from parents if they don't care of him and etc. Because in this situation, this is a child, he will die or suffer for maybe a whole life. And
but that's a very sensitive topic. I mean, in Germany, the exact way would be about such an agency, like a youth welfare office, that the doctor just call them and they apply in court. But the problem about that is always that you kind of split the family. So in that moment when you apply on such an office or agency, it's very difficult to keep the child in this family, because I mean that would lead to the decision that those religious interests would contradict the children's well-being, but the first interest is always to keep the family together. So you have to decide very, very carefully if you want them to be involved. And yes, so.
And do the right of doctors to interfere, to go to some agency, governmental agency, is written in the law? So it is.
Yes, in some cases. For example, in case of abuse, they are obliged to go to them, and I think
in this case,
it's not obliged. It's well, it depends on the engagement of, or on the involvement of this doctor. So they have much more to do than their medical treatment stuff itself, I think.
But how would they, in practice in Germany, how would they act? So do they go to some governmental agencies, or they will leave it?
No, since this decision, I think they will do the best they can. So the patient's interest is the most value thing to the medical doctors, I think.
And do you have another side of medal? So the prosecutors, in the case if medical staff is I will explain. If the medical staff is out of any activity, I mean, does not take any measures to convince the person, or maybe they convinced, but they were, but they lose that. Chance to convince, and they do not go to the governmental authority. So do the prosecutors in the case of the death of the patient have the right to prosecute that person?
Yes, in case that they know about this, yes.
Okay.
But
So
that's a reality problem that in this field nearly nobody knows what's right, what's wrong. Every medicine doctor thinks that he's always standing with one foot in the prison. So they are asking the clinical lawyers for everything. And in case they don't do, or and then some situation developed very bad, it's hard to find a person who tells the prosecutor. So that's more the problem, that how got they knowledge about that.
I see. Yeah, it's very interesting because to hear the point of view of the Russian medical lawyer, because do we have such cases? But I think that if we would be lucky, and I hope we would be, so we would make such a round table with the participants of the Russian medical lawyer to find out these questions. And if Sandra, you would be able to take part, even via conference,
that would be great.
Yeah, I would be very happy, because really I can only imagine, because I'm not an expert in this sphere. And so, okay, so what would we decide? Do we continue or what? It's up to this the decision of members.
I would just suggest to summarize case 4, because it's kind of linking to the things I tried to explain earlier. So with that, if everyone's fine with that.
Okay, then if you do not mind, I would read it. O is 68 years old and is in a coma for 6 months after having a stroke. The physicians do not expect him to wake up again. O's daughter D has only family member knows that her father would not like to spend the rest of his life like that, because she had a talk with him before and he was planning to create a living will in regard to such circumstances. Because there is no valid patient's will, the treating doctor turns down these requests of switching off life sustaining measures until O finally dies 3 years later. D wants to claim compensation in her father's name for bodily harm by keeping him alive against his will. Successfully? What do you think?
I think it's not successfully.
Why?
Because there was, we have no will, written will, and that's why we can't prove his will. That's why. I think keeping him alive, it's not such a harm for his body. And maybe if his daughter had a great will to turn him off, I think she had to ask maybe judges, courts, or any other people who could make some
I know that's not named in this case, but that's actually what she did, and that's why it took so long. So decisions in Germany take a little longer. So this is why.
Okay. The daughter asked everyone who could.
Yeah.
Mm-hmm.
And he died before there was a decision. So.
Okay, and that's how the German law is. I think it's not hard for a body to keep him alive by treatments and by some operations. I think it's without written will, we can't tell everybody that it was really so. That's why it's unsuccessful. No. That is my point of view.
Thank you very much. Thank you very much for your for sharing your opinion. Okay, somebody else? Nobody. Then Sandra.
Yeah. Yes. Yeah. As it was said, it's hard to prove, but in fact, it's not relevant if something is provable or not. So it was clear the daughter knew that he didn't want to stay alive, and he told her, she told, and it's not that way that only a living will could make it possible to turn off some life-sustaining measures. So I think, yeah, they were meant to listen to her and figure out if it's the true or it's not. But it should not be relevant if there is a living will or not. But that was also a case which was decided last year from the highest court in Germany. And this goes back to the idea that as long as you are treating a body against somebody's will, it would be harmful to his body. It would be able to be compensated. But now there's just an ethical idea added, and they say that sustaining life could never case compensation. So it's not a legally decision, it's just more like an overstanding and basic principle decision that ending life is never caused, not ending, but keeping life by life-sustaining measures could never cause compensation. So you were totally right that it's not successfully. But it's quite a strange decision according to the German law. Yes.
So as far as I understood, it is not possible to if there is no any will and if there is no any decision of doctors, so it's impossible to ask for compensation if they continue to make the person alive in regardless of the this life sustaining equipment. Am I right?
Yeah, due to this decision, that's right. But that contradicts all the other decisions before about the patient's will, and that it's your own decision how to treat your body. And I mean, it's a still ongoing decision about ending life. So like suicide or just helping suicide and all those stuff. So this decision is going like, I don't know, 15 years back.
So it means that earlier, if there were such case, if the daughter or very close relative told that, so the person do not want to be in such a condition, the doctors have to follow all these idea and to switch off these.
No, earlier nobody tried to get compensation out of that. But yes, it's always a doctor's decision. So no doctor can be forced to switch off measures if it's against their own way of life or if they don't agree. But yeah, I think this area is not discussed already till the end. So there's many questions, and it always depends on an individual case. So in that case, if the first doctor would have turned the measures off, then everything would have been fine. And yeah, as I said, it's strange to say that treatment against somebody's will is not wanted, or is not it cannot be the excuse if the doctor just says or thinks that it's the best for him, because the decision what is best is the patient's decision. And on the other hand, yeah, it's quite difficult to deal with this question in general.
But in the case you they would charge the compensation, so if they would, I understood that they didn't, but so nevertheless, if they would, so we can go to the very slippery, or Germany can go to the very slippery way. For example, when the person is unconscious and he cannot agreed or disagreed or to prove the words of the relatives, they can say yes, he didn't want to live, so he want to die.
Yeah,
and
that's
because of the because of the some financial interests and
yeah, okay, yeah, I think that's the reason why so many people just take their hands off and say, no, I won't switch anything off. But that's also part of the job. He has to figure out what the real intent or the real will of the patient was, and that's quite, it's like a job you can't do correctly. It's how could somebody know what was?
I think that in Germany is the same situation as in Russia and maybe in other countries. Doctors have to be not only doctors, they have to be also investigators. To find out what is the main reason, or they also have to be the judges and I don't know whom else, because so it's really very difficult, and I think it's not good for the health conditions, for the system of health in reality, because they have to pay attention to many other issues, not to the main issue to treat. And that is, we think what would be, what would not be, for what they would be in charge of, and so on. And these questions are like obstacles in the treatment, maybe sometimes. So it's that is the main idea.
As far as I see, I think the most doctors are very enthusiastic, and they always try their best. So I've done some internship in several hospitals, and it was always the same, that they are over engaged, and you can't say that they don't try their best to get every situation managed. But due to this, I think in the last few years, it started that at university for medical students. There are also some general lectures about what they have to know in, for example, ethical conversations, and also in law stuff. So
I'm not sure that our students of medical schools have such courses on the legal aspects. But I think that we would also come to such a situation, then there would be such necessity. Yeah, really.
Yeah.
Okay.
I know about our
You know,
students.
yeah.
Yes, they also have some subjects which are similar to ethics of doctors, and also there are a lot of such things in other subjects. And as I know, also our students in medical universities, they also have some subjects like legal law, economics, and there are a lot of it.
That's great. I think
maybe, I'm not sure. I know that the students of economy universities do have legal classes, classes on law, but I have never heard about the medical schools. Maybe they have some general parts or something like this. I'm not sure. I would not say anything in this sphere. I was sure that no, but so maybe I'm mistaken. So, do you have any questions? I know that our meeting was a little bit spontaneous and was interrupted by different obstacles. Sorry for that, really sorry. I wanted to make it, Sandra, as informative as possible, because I think it's really very interesting topic. It's very, I should say, maybe urgent in some situations. And I hope that maybe a little bit you got from this meeting, and maybe you've started to think of something. It is also very important, because in Russia this sphere is very unresearched, if we can say so. So it means that we have to find tools in creating the regulation, good legal regulation, effective legal regulation, but not only formal regulation. And in this case, I think it was very informative to listen to the experience of Germany that was well given by Sandra, and thank you for this chance again. I hope that it was not the last, it was our first, but not the last meeting, and I'm sure that we will continue this series of medical law meetings, and so we would try to go deeper in this sphere. Okay, so do you want to say something? No? So it's...
I would like to say thank you, everybody. I would like to say thank you to Sandra, because all the aspects of this theme are very difficult and are very huge. They are unresearchable, as Maria said, in Russian legislation. And if you ever made a consent on operation in Russia, you will know that death according to this operation is okay, and you are signing to the death almost. That's why all researchers against consent, abuse of rights of patients and doctors, I think it's a very, very huge theme. And I hope that there will be more roundtables, medical roundtables, and we will see you again. Thank you.
Yes. Thank you for all guests, for all members that you are support, that you have shown your interest, and that you spend your time, your own time on discussing. And again, sorry for some technical obstacles. So I hope that next time we would be better. We would be more lucky. Okay. Then thank you very much, and I think that it was productive nevertheless, and so see you next time on our next meeting that we would prepare for you.
And thank you very much for the invitation.
Thank you very much.
Thank you.
Thank you, Lisa. Thank you.
Yes.
Bye-bye.
Bye.
Bye-bye.
Stay safe.
Yes, everybody.